now.
Well, now we do have a quorum for the zoning board, so I would propose that we open the hearing. This is a virtual meeting via Zoom. It's the Zoning Board of Appeals, Tuesday, January 5th, 2021, 7:31 p.m. And sitting as the Board of Appeals are Dave McMorris, myself, Woody Chidick, Matt Watkins, and Lee Darst. Charlie Higginson is expected very, very shortly. So I'm calling the meeting to order. Jen, do you have any instructions that you would wish to give us, or?
If you don't mind, Mr. Chairman, just calling the meeting to order with a roll call vote, and then we will also go through, as we usually do with the hearings that are open, and make sure we promote people ahead of time for the hearings at
Okay.
hand. So we just need a roll call vote.
Okay,
here's
Woody
Charlie,
Chidick's here.
and Charlie's signing on.
Okay, Woody Chidick's just signed on. Other?
Darst.
Okay, Lee's done it.
Matt Watkins.
Matt, Dave,
Dave McMorris.
Charlie, you're muted, but you're there. Okay, so Jen, we have the 5 board members so far.
Great. And for 31 River Road, we have Roger Hoyt, who I did mute. He was here.
I'm here.
Oh, okay. And also Attorney Brodsky.
I'd like Adam to make the presentation
Sure.
for us tonight. Thank you.
Okay, Adam, would you proceed? Obviously, we've had a couple of hearings now, and we did receive some material over the last month. But if you want to succinctly just sort of summarize where you and your client are, I appreciate it, and associate, Roger, and wife.
Thank you, Mr. Chidick. Can you hear me?
Yep.
Good evening, everyone, and Happy New Year. Together with Roger, we represent Randy and Andrea Steele, and you'll remember that this is an application for a special permit for an addition to an existing workshop and garage. And on December 8th, at the request of the board, we submitted a request to amend our petition for relief within the floodplain pursuant to section 309.6 or alternatively 309.11. You may recall that we relocated the proposed addition to physically attached to the building to eliminate the pergola. And as a result, a small portion of the addition is now within the floodplain. It's approximately 51 square feet within the FEMA AE flood zone. As a result, we're seeking a special permit for that. The construction is slab on grade with flood vents, and the addition is designed to comply with the flood resistant construction requirements of the Massachusetts Building Code. And for all the reasons in my December 8th letter, we meet all the requirements under 309.7H. Although alternatively, the board can grant relief under 300-911 because we're extending a non-conforming structure in the floodplain, and the ground area coverage of the structure on the lot is not increased by more than 20%. If my math is correct, I believe we're slightly less than a 10% increase to that non-conforming structure. So we're asking for a special permit to extend the existing non-conformity for the addition, as well as a floodplain special permit. Thank you.
Okay. So board members, you've all received the material, I presume. And who would like to ask questions of Attorney Brodsky or any of his colleagues?
No, I mean, this is Matt Watkins. I recall at the last meeting, right, the plan had been altered, and there is, as a result of that altering, there is some additional impact within the floodplain. That's still the latest and greatest, Adam, correct?
Yes, Mr. Watkins, that's correct. Since we slid the addition over to connect with the existing structure, we have that small corner that's now in the floodplain, which is why we're asking for a floodplain special permit in addition to our ordinary relief.
Okay, understood. Thank you.
I do think the questions that we had on, extending the existing nonconformities were pretty well satisfied before. And my understanding is that this piece here is kind of crossing the Ts and dotting the Is. So I'm satisfied with what we have.
Would you agree, Adam?
Yes, sir.
How about you, Lee?
I don't have any questions. We have talked about this project on several other meetings, so I'm fine.
Okay, and Charlie?
No problems.
I don't either. We do have time reserved for deliberations later in the evening. So, yeah, Charlie. Oh, sorry. Were you signaling you wanted to speak, or just? I guess not. I guess not. Okay, Charlie, are you?
I move that we close the hearing.
Oh, okay. Okay. All right. It's been moved. Any discussion, or do we have a second?
Dave McMorris, second.
Okay, so moved and seconded to close the hearing. All in favor, aye. Woody Chidick, aye.
I, Lee Darst.
Hi, Cheryl Higginson.
I'm Matt Watkins.
Hi, Dave McMorris.
Okay, 5-0 to close the hearing. And if everything goes well, we will deliberate this later on this evening.
Thank you very much, everyone.
Okay, thank you.
Happy New Year to all.
Thank you.
Okay, our next is a hearing at 62 Rust Way. Clients Thomas and Eileen Norton, clients of Kavanaugh Consultant, wanted to construct an addition within the setback at the rear of the house. They have requested a continuation until February 2nd, obviously to rethink their proposal. Do I hear a motion to accept the applicant's request to continue their hearing?
I motion that we accept the applicant's continuation of the hearing.
All right, second.
A second.
Charlie seconded, and all in favor, Woody Chidick, aye.
Lee Darst, aye.
Cheryl Higginson, aye.
Matt Watkins, aye.
Dave McMorris, aye.
Okay, so 5-0, that's continued until February 2nd. We didn't get at the next meeting dates, but we can loop back on that, Jen, after our hearings. But for right now, at least, it's February 2nd. Third hearing is we opened it last, and this is not so much been before us for a long time, but it's been wending its way through various town boards, and that has to do with Elm Street Realty, the Harbor Project at 124 and 87 Elm Street. The project has certainly changed and morphed quite a bit. But since we met on this, Adam, in the beginning of December, you've submitted a fair amount of material. Would you like to speak on behalf of your clients? Well, sorry, Jen. What?
Would you, I just wanted to ask Attorney Brodsky if you would like me to promote, I know that you have several attendees. Would you like to John Cavanero and the two applicants as well?
Thank you very much, Ms. Oram,
Okay,
Mr.
great.
McGoldrick, and Mr. Lubitz.
Perfect. Thank you.
At this time, I'm going to recuse myself because I have a
Okay.
conflict.
All right, Leah's recusing herself due to conflict. Okay, so Adam, take us through And we will, after you tell us what we, or recap, if you will, what we've received over the last month, and have the board ask questions, if any. We'll then open it to the applicants or other citizens. But why don't you take us through what the gist of what you submitted? I mean, you did have one that went 38 pages, I see, but not to be daunted, I actually flipped through all of them.
Thank you, Mr. Chittick. Good evening, everyone. I represent Elm Street Realty LLC. We have this evening George McGoldrick and Ted Lubritz, members of the applicant entity, as well as John Cavanaro, our registered professional engineer. And this project concerns the redevelopment of the existing structures at 124 and 87 Elm Street. And we're seeking a floodplain special permit under section 309.6 for a new mixed use project. I also note that the project is also located within the watershed protection district. At our last meeting, you gave me 3 deliverables, which I hopefully have provided to you. First, you asked the question of how the west building, that is the building at 87 Elm Street, satisfies in particular the requirement of 300-9.7H2, which you will remember says in effect that if the land is subject to tidal action or adjacent to tidal waters, the proposed structure or use is not less than 10 feet above mean sea level. Second, you wanted plans showing the proposed flood vents, because I represented to you that in fact the new structures will be entirely flood compliant. And so we provided to you sketches from Cavanaro Consulting, one for each of the properties, which shows those flood vents. And third, you asked for an emergency parking plan, which we proposed and provided. And I just want to update you that in fact, we do have an agreement with St. Anthony's Church to be able to use its parking lot for emergency parking. And I'd like to address the first issue, if I may, and then John is available to address the flood vent plans if you have any questions regarding that.
Okay, Adam,
again,
just quickly, would you address both 1 and 2 under H? One being the tendency possibly to flood, and then 2 is the 10-foot elevation.
Yes. So, and I'll have to. Sure, I'll have to defer to George and Ted, as well as John, who have more particular expertise, but I do not believe that there's any history of flooding in the upland portion of 87 Elm Street, which is what you're concerned about.
And you did provide some past applications and things, but I'll let you deal with that.
Yes, sir. Well, you asked me to address H1, that the proposed structure or use is not subject to damage by flooding or waves, nor is the land unsuitable for the proposed structure or use because of drainage conditions. The first point I was making is that this is not, at least the upland portions of the property are not regularly subjected to flooding, and I'll defer to those with more personal knowledge. And second, as you know, John can address stormwater management and flood resistant construction in far more detail if you want more information. But we believe that the site conforms to the requirements of section 1. And it was section 2 that you had particularly asked me to write on. And I'll try and be brief. I realized that my letter was lengthy, but it was mostly the attachments, and I tried to be as succinct as possible. But candidly, 309.7H2 is not applicable. 87 Elm Street is not subject to tidal action and is not adjacent to tidal action. And therefore that provision doesn't apply. And this board has already made that determination for several properties on the James Brook. In particular, I provided you with several decisions relating to 85 and 81 Elm Street adjacent properties. And the board has previously determined that James Brook is not tidal on account of the sluice gates. Those decisions allowed additions to non-flood compliant structures. And I just remind the board in this instance, we're proposing to raise the existing non-flood compliant structures and construct new structures that meet the NFIP and the building code requirements for construction within the floodplain. So because this land is not subject to tidal action or adjacent to tidewaters, we don't need to comply with the requirements of H2 as previously determined by the board for this portion of Cohasset. But if however, you determine that 309.7 H2 is applicable, I suggest that your bylaw should be read consistent with the NFIP, National Flood Insurance Program regulations, and the state building code requirements for flood protection. And we discussed a little bit of this at the last meeting. I understand that your bylaw, that particular section, was amended in 2017 to regulate uses. So previously it spoke to structures in the floodplain, and then the concept of uses was added to that provision. And I'm informed that that was to grant the board more flexibility in dealing with projects like this. All of the commercial and residential uses for the project at 87 Elm Street are located above the design flood elevation. That's a requirement of the NFIP and the building code, which require that the lowest floor of the building be above the design flood elevation. And the definitions of lowest floor, which appear both in the NFIP regulations as well as the building code, expressly exclude unfinished or flood-resistant enclosures for parking, building access, or storage. And so under the federal and the state regulations regarding flood protection, parking and building access are permitted below the design flood elevation. And so 10 mean sea levels, a different datum that is used for floodplain mapping. And if I have this correct, 10 mean sea level is approximately 9.2 NAVD88, which is used for the floodplain mapping and also used as the datum for this project. And the design flood elevation has to be 1 foot above that, so it has to be 10.2 NAVD88. All of the commercial and residential uses at 87 Elm Street are above 10.2 NAVD88. The parking and building access are below that elevation, but are expressly permitted under both federal and state regulation. Importantly, when town meeting changed the bylaw, it focused now on uses within the floodplain. And I'd respectfully suggest that 9.7 H2 should be read consistent with the federal and state requirements for work within the floodplain. And we have ensured that all of our uses are above 10 mean sea level and satisfy, I think, the letter of the regulation as well as the intent of the regulation. But if there's any ambiguity in the interpretation of your bylaw, it should be read entirely consistent with the federal and state requirements for floodplain protection. I think a contrary interpretation, which would prohibit all structures below 10 mean sea level within the floodplain in Cohasset, is contrary to the precedent of this board and would lead to unreasonable results. And I don't think that was the intention of the amendment in 2017. So in short, 9.7 H2 does not apply because this land is not subject to tidal action. And if it does apply, the uses of the project are all above the design flood elevation consistent with federal and state regulations, which recognize that you can have, for example, parking and building access below the design flood elevation. So I'm happy to answer any questions you have with respect to that issue. Again, John is available to speak to the sketches and any questions you have regarding specifics of flood resistant construction. And Ted and George are available also to answer any questions you may have with respect to the proposed management plan if I cannot. Thank you.
Okay, board members. Dave?
I think the issues that I had in mind last time have been answered and satisfied.
Charlie? Anything?
I agree. It could lead to an interesting situation that they would be, if the floodgates were open, therefore the tide would be going up and down on the James River, then it would apply. While if the tide gates are closed, it wouldn't. So the thing would be flopping back and forth with a tide gate.
Yeah, and my understanding is the tide gates are open to drain the marsh, not, well, actually not entirely, to let salt water in too, to take care of Phragmites, but I haven't seen any evidence of that being effective. But that's another issue. Not before us. How about you, Matt?
I don't think I have any questions on it.
Nor did I on this issue.
I just
Sorry,
have one.
go ahead, John. This is John Pallett, our new building inspector.
Yeah, oh, just one question too. The utilities also will be above the floodplain elevation as well. So in the storage or garage area, there's not the air conditioning condensers or any of those utilities. So just, I think it's pretty clear in the code, but just, I think they're aware of it also.
Would you concur, John and Adam?
Yes, that's correct.
Okay, great. Okay, does anybody listening in wish to speak on this particular issue of parking at 87? Oh, I don't hear anything, so we won't close it off necessarily if somebody wants to jump in a bit, but hearing nothing, do you want to move on, Adam? And you,
Mr. Chegg, that's the substance of the presentation.
Okay.
I hopefully answered all of your questions that were raised, at the last hearing.
I've got on a sort of a different topic, and you'll have to refresh my memory. Where do we stand on the configuration of the parking spaces on both properties? Not the number of, that's a planning board issue, but the size of the parking spaces. You made those compliant, I believe?
We made them
Originally,
compliant.
they weren't.
Yes, sir. We made them compliant, and John will correct me, within the footprint of the building at 124 and 87. The only place where they're not compliant is in the town parking lot. And we've requested the planning board, to the extent that we need relief, because the planning board is the special permit granting authority within the overlay district, to allow us to extend the existing non-conforming parking within the town parking lot that extends onto our property. And so I believe we proposed 4 additional spaces on our property as part of the quote-unquote town parking lot, which are similar in size to what exists but don't presently conform. And to the extent we need relief, the planning board has indicated to us that they consider that request.
Well, just curious, why wouldn't that be a variance that would come before the zoning board? The overlay district doesn't give the planning board any authority over what they call waivers or variances, of course.
And we have a respectful disagreement, Mr. Chittick. The overlay bylaw makes the planning board the special permit granting authority within that district. And the request to extend an existing non-conforming condition would go to that special permit granting authority. So it's a request for a special permit, not a request for a variance from the zoning board. I would agree with you that if indeed it was a variance, that jurisdiction lies entirely with the zoning board of appeals. But that relief can be granted by the planning board sitting as the special permit granting authority within the overlay district.
Well, what do you mean that relief? You mean the extension of a nonconformity?
Yes, sir.
And you're saying you're adding 4 spaces?
Yes, sir. Within essentially the existing parking area. That's correct.
I'm not sure I see it exactly that way, but anyway, board members, do you want to speak to this issue? I mean, it's to my mind, the reading of our Article 22 is quite clear that it gives the special permit granting authority, the planning board, certainly jurisdiction over the number of spaces, configuration, but not in terms of size, where it says that they must comply with 7.1. And I'm not sure. I mean, is this, in the board's estimation, an extension of a nonconformity? In which case, sure, it'd be a classic 8.7, I guess, or not.
So Mr. Chick, I don't mean to pick a fight with you in the new year, but I mean, there is no request for relief to this board with respect to parking. And again,
Okay, no, but if we determine that you did need relief from this board, you're obviously well advised to deal with it rather than have us make you come back later. I mean,
I don't
you don't want that, I'm sure.
I don't disagree, but I respectfully suggest that decision in the first instance would need to be made by the planning board and not the zoning board.
No, we can perhaps disagree on that.
Yes, sir.
Why do you cite, what are you citing as authority for saying the planning board has to agree that the zoning board has jurisdiction?
The bylaw expressly grants the special permit granting authority to the planning board. So the planning board in the first instance would make a determination whether a request for special permit relief was justified or not. The zoning board wouldn't have a role in that. That's for the planning board to decide.
Okay, has the planning board closed its hearing?
No, sir.
No, okay, well, might want to have a chat with them. I might want to, and we'll see where that goes. No, I just think it would be better to clarify everything.
Yes, no, and we have addressed that issue with the planning board and with town council. So it's not like we've swept that under the rug, and we're not trying to circumvent this board's jurisdiction at all. It's simply, my understanding is when the bylaw was adopted, the overlay district, it was intended to create one-stop shopping. So we didn't have to go back and forth between boards.
Sure.
That's why they granted that authority to the planning board. And we're simply trying to work through this novel project through the bylaw.
Well, maybe what I'd like to do is ask Cindy Amara, who's sitting in. The last piece of paper, if you will, that I have in front of me from town council, Karis North, is dated October 7th, in which case she ends a 4-page memo saying, therefore, without specific authority allowing a waiver of parking space and configurations, in my opinion, the planning board may not waive these requirements. She's dealing with space.
Yes, sir.
So
And that's why we did a redesign of the parking spaces for the project.
Okay, and if I don't have that, that's probably from Karis North. It's undoubtedly my fault for misfiling. You don't want to really look beyond what you see here to see what a mess my home office is. So I'll take the blame.
No, the point being, as a result of that determination, we went back and we redesigned the parking so that the parking spaces.
Yeah, that's what I thought, but I had kind of missed, I guess, the point I recall now, you talking about the town spaces.
That's correct.
But you're adding 4 spaces.
And John will correct me if I'm mistaken.
Yeah, I believe it's actually, it's 2 spaces in the town lot.
Which the town can do, okay.
Yeah, so that all the new non-conforming spaces are in the town lot.
Oh, okay, I thought Adam said there were a couple on the property at 124.
Well, a portion of the town lot is located on 124.
Yeah, we're calling that the town lot, but it's all within that. Some of it's on our property. A lot of the town spaces are on the town's land, but it's all.
So you're telling me that there are no undersized spaces on your property? They may exist in the town property, but not in yours. No?
No, that's true. They will. We're continuing an existing nonconformity with respect to parking spaces in that lot.
In that lot, not on your own property? Cindy, you're
Well-
blocked. Let me ask Cindy, you're muted.
It's on our property, but it's in the area of the town lot.
That's what I understood them to say, that there is a portion of the town lot with smaller spaces, if I understand correctly, that may be located on their private property, and they're adding spaces to the town lot where there are smaller spaces already, but it is on their property. That's my understanding of what I just heard.
That's
That's
correct.
correct.
Mr. McGoldrick has something to say. on
Okay,
that, Mr.
George?
Chair.
Mr. Chair, for those that may not be aware, the town parking lot behind the Veterans Memorial, there is a lot line that runs, very jagged lot line that runs through that town parking lot. We had approached the town over almost a year and a half ago to talk about a land swap, because we were not going to use those parking spaces and wanted to keep them within the town. But because a land swap requires not only a town meeting vote, but also state legislation, it was decided that we would go back to the selectmen and just do an easement, do cross easements between the two parties. So the spaces that we're talking about, they're legally on our property, but we are going to be we're going to be working on an easement with the town so that the town has the rights to them. So that's the distinction between it's our land, but there's the town will have an easement for those spaces. And those are for public spaces. They're not spaces for our project.
Okay. Cindy, do you have anything to add to this?
I don't think anyone's going to like what I am going to add, in that this is the first I've really become aware of this issue. So I would, I would want to speak to Karis about her belief and what she was referencing and what her understanding of the situation was when she made that opinion. So if I understand correctly, the town will have the right to those spaces, and essentially the developer is creating them for the town, and they will be municipal spaces. Is that correct?
Not used by any of the residents of the condominiums?
They will not be residential parking. It will be sort of small P public parking.
What does that mean?
Means for anybody in town who would like to park there can park there.
Well, is there a distinct? Yeah, I mean, that would be my understanding too, Ted. I mean, I don't know if there's a difference between a small P and a large P.
Well, there'll be guests of our project too. For instance, we'll be having some retail uses.
Oh, I see. Okay.
Yeah, that's what I mean by small P. It's not a municipal parking lot per se.
Do those spaces that will be in the town lot count towards parking spaces you need for your project, or are they in addition to?
They are counted towards the commercial parking count. But as Ted said, they're not designated as residential spots for the private residential use.
So,
It's a mix. Go
oh, I'm
ahead.
sorry, John. No. So I might suggest, Mr. Chair, this is some of the problem, because Ms. Amara hasn't been involved in the discussions with Karis North and the planning board regarding the parking. And we have advanced much further since October regarding, as I said, the parking was reconfigured to respond to Ms. North's opinions. And we've already had all of these conversations with the planning board. And so this is some of the difficulty of the zoning board weighing in on a parking issue, which I respectfully suggest is not presently before it. And Ms. Amara is at a great disadvantage because she hasn't been involved in all of the conversations we've had regarding parking in this project, which have been extensive.
Okay, well, we can certainly, we'd have to continue anyway after the night to deal with content and possibly a draft decision. So it certainly would not interfere with anything if we also, in the interim, are able to communicate with Terrace North and find out if she's satisfied that our any of our obligations in terms of spacing on these spaces are moot, and really our planning board within their purview. I'll listen to town council on this one. I mean, we're not trying to create new law here. But I don't know, what about the board? You've been quiet.
I have nothing to add to this conversation.
Okay.
This sounds like a lawyer issue.
Great. In a nutshell, is the question really whether you need a finding of no more detriment from the ZBA versus whatever requirement you need from the planning board?
Yeah, the first finding is it a special permit versus a variance? What you're citing only applies to a special permit. That may be the operative bylaw here. You know, the finding for a variance is different.
Absolutely.
I mean, that's not a test, what you cited for a variance. But I'd like to hear from Terrace North, and as I say, this may have moved far beyond where we were. I know the planning board has met extensively on this, and I think Terrace has sat in on most of those planning board hearings, has she not?
Yes, Mr. Chittick. I mean, we're at last strokes. We're anticipating a draft decision from the planning board this week with a meeting next week to try and close the public hearing and obtain a decision. And as I said, we've had extensive discussions regarding this particular issue with Ms. North and as well as the planning board.
Okay, well, it's very likely that if Terrace North agrees with you, the zoning board is not going to get in the way here on this. But I'd like to hear from her and you know, debate back and forth a bit.
Of course.
I'll be happy to talk to Karis between now and your next hearing, and also Adam if we have any questions between the two of us, and let you know what she says.
Thank you.
Okay. Board, any other questions for the applicants at this point? Any other information you'd like to see? I'm getting a lot of silence here. Are there people in the audience who'd like to weigh in, make comments?
There's one woman asking a question, CC Franklin, but it is regarding the parking. So I don't know whether you want to refer her back to the planning board, but it says, are there any assurances that those spaces won't be taken up by residents?
How might you address that, Adam?
We're providing residential parking within the buildings on the properties.
So unless somebody had extra automobiles that they might have to put somewhere, they could also go over in back of 87 too, rather than interfere with, you know, it is important, I think, that this project has been proposed as one that will widen or open up access of the public to the harbor. And it'd be a shame if that access were impaired because there was no parking for me driving from Forest Avenue or someplace that, you know, it's too far to walk.
All of the proposed parking meets the requirements of the zoning bylaw.
Okay, I hear you.
Actually, I had one question, maybe it's for John, but the piece about the, just pulling it up here, the relocation of the vehicles up to 15 cars in the event of a major flooding event. Is there a threshold as to kind of what you determine the major flooding event to be and kind of how often that would be utilized?
Well, it would really depend on the severity of the issue, but you know, the parking is cited, especially at 87, where, as we've talked about, it's controlled by a tide gate. But I think that the issue that the board is asking for was, do you have an emergency plan to essentially evacuate the entire building, to have a a location to put those 15 spaces that are designated for the residents at a location or locations to be assigned. And I think that's what, so I think the answer is all the spaces are accounted for in terms of a relocation under the emergency plan.
Okay.
I have to say, we've had in the month of December some pretty lousy weather, and I've gone by there frequently and haven't seen more than a puddle at the edge.
Yeah, and that's
most times.
That's not coming from a coastal event. That's coming from surface water down.
I understand, and if there's going to be flooding, I think it's probably going to be surface water coming down from the hillside. But I couldn't see any. That's, what does that matter? I mean, that's a mother-in-law survey, but I didn't see what I might have expected to see, and that was flooding of some sort. Just didn't happen, which is good news. I mean, I suspect also that an owner of an automobile there, if it is going to start to flood, has got to exert common sense, and is probably not going to wait for their doorbell to ring. If it looks like it's getting up to the hubcaps or the axle, I think you're going to want to move your car if you're in residence, which you probably are. You wouldn't have a car there. But who knows? I mean, I'm not trying to solve that, but it wasn't as serious as I thought it could be, at least by observation. Okay, I would like to make a motion that we continue this until next month, and we'll talk toward the end here about drafting a decision, who draws the straw, etc. Because as is typical of this board, we don't want to be unduly pressured into making a decision, deliberating, making a decision, writing it, and filing it in very short order. So that's why we would continue. But let me ask the board, is there any more information anyone on the board would like to see from the applicants, or do we have what we need?
I don't have any.
I'm satisfied with the status quo.
Sounds like we have what we need.
Mm-hmm.
Okay, so I'd like to make a motion that we continue this until February 2nd. And we'll talk a bit more about this later on in terms of who's going to be preparing points of view.
I'll second the motion.
Okay, moved and seconded. All in favor, Woody Chidick, aye.
Dave
Charlie
Bishop,
Higginson, aye.
Matt Watkins, aye.
Okay, and Lee's obviously recused. Okay, so that's the hearing is continued, but no further information has been requested.
Thank you, Mr. Chittick. Thank you, everyone, for your time this evening.
Okay,
Thank you.
great.
Thank you.
Okay, the next hearing is one that I'm going to recuse myself on. It's, I think this is the one, isn't it? Jen Louise Casden's
Yes, it's
a detached garage and dock. So I'm going to ask Charlie Higginson as our third. Is he? Yeah, there he is, as our third voting member. Charlie, would you take over the hearing in this case? This is the Casden dock and garage.
Yes, are they there now?
Well,
John
they're
Cavanero.
on the agenda.
Yes.
But I'm
John, yes,
I'm
you
going
are.
to mute myself and.
Okay. Good evening. Just for the record, John Cavanero from Cavanero Consulting. We were continued at the last hearing. We weren't asked for any new information at that hearing, but we did have a hearing with the Conservation Commission subsequent to our zoning board hearing, and they asked for some additional information. Two things specifically. We received a letter from Division of Marine Fisheries asking us to, we had originally planned to relocate some boulders that were in the rocky intertidal area, essentially along the path of the dock, and they suggested that we leave those boulders in place. So as a result, we rotated the dock to avoid the boulders, so the boulders don't need to get relocated. And second, they asked us to add the trees within the vicinity, within the close proximity to the proposed garage. So we added those trees to the plan, and we submitted an updated plan to the board. And that was the only change we received from the Conservation Commission. So we'll be going back in front of them this week, hopefully for closure.
John, I think from standpoint of our jurisdiction, nothing's changed on the flood issues for the garage, correct?
Correct.
And our jurisdiction regarding the dock was essentially just the landing that the dock is coming off of. That's not changed either, has it?
No.
Okay, thanks.
Matt, do you have any questions?
No, I don't.
Do you have any questions? No. So
I don't have any questions either.
No. So I would move that we close the hearing and deliberate later this evening.
Second. Can we?
We just need a roll call.
And aye.
Lee Darcey.
Matt Watkins, aye.
Dave McMorris, aye.
Thank you.
Unanimous. Go ahead.
I just wanted to say that if I was okay, I don't believe we need special counsel Cindy Amara any further, so I just didn't want to have her sit so she could exit for the evening, and thank her. So,
Thank you.
Thank you.
Okay.
And the
So
next
we
one is-
want Woody back.
We want Woody
There.
back. There's
I'm back, and now we're over at 72 North Main Street. The Morse Engineering is handling this case for their clients, the Vanderwiles. It's again a dock. Who's here to speak for them?
Thank you, Jeff Hassett with Morse Engineering.
Okay.
Yeah, so the only outstanding issue at the last hearing was the matter of a view easement described in the deed. Following the hearing, I looked into it, and it's apparent that that easement is only applicable to a small area on the northerly side of the property, so on the opposite side of the property from the dock. So it has no impact on the project after looking at the deed and the record plan.
Okay, not applicable. Go ahead. So who's wanted to speak? Charlie, were you saying something?
No.
Okay. Dave or Matt or Lee?
We do have the deed which referenced that view easement. Did you say you had a I don't know if it makes any, if you happen to have that depicted on a plot plan, I would say there's no harm in submitting it to us just to have with.
Yeah, I did email it to Jen following the meeting.
Okay.
I have it on my computer. I can share my screen if you want to see it.
That's fine. If Jen has it.
I did. I think I forwarded it, but I sent so many documents, and if you scroll down, it was in there.
Yeah.
But I can also resend it. But I did send it out, Jeff. Just so you know.
Yeah. The Vanderwheels purchased a piece of land from the abutters, and that easement only applied to that small portion that they bought from the neighbor.
Okay. Well, I think there's no harm after we hear from anybody in the audience to continue this particular hearing until February. In the interim, we'll draft a decision and things, but it also give us an opportunity to take a look at these easements just to confirm what you're saying. I don't doubt.
Well, Woody, I think we might be in a position where, unless others disagree, I might have missed that in the packet, but we did review the language in the easement, so I think we're comfortable now with the understanding that it's on the opposite side of the parcel that we would be able to close the hearing tonight and deliberate. I did have just a couple of questions, but.
Well, go ahead, ask them now.
Well, I think that was one of them. And then as far as the revision to the site plan, right, it looked to just be an alteration to the size of the float, which included a 3x3 landing. And was that, I didn't have anything from the Conservation Commission. So was that a result of, did you go to the Conservation Commission and get your order of conditions? That was part of it?
Exactly. Conservation has approved it.
Okay.
And they asked for some revisions that we made. They really didn't impact the design too much. That landing, like as you mentioned, and then there are a couple of things like we specified the piles to be 12-inch maximum diameter, and they wanted us to do a little more homework on that and specify an actual size for the piles.
Okay. And that's where I think I saw 8 by 8.
Yeah. Yeah.
Okay.
A question for Jen. If we close this hearing, Jen, I don't see you. Oh, yeah. If we close the hearing tonight, what's the filing deadline?
I believe it would be 14 days, but I believe I forwarded a draft. Did I not, Matt?
Yeah, I did put together a draft on this week.
That's what I had seen. Yeah. So
Yes. So we're fine. If you, I think if you deliberate, and I know that we do have the plan, and like I said, I can pull it up again while we're deliberating and forward it to everybody if we need. But I think you are all set, but it's up to the board, of course.
okay. How does the board feel about closing tonight and deliberating and then having the clock tick for 14-day filing?
I'm fine with that.
I'm fine.
Yep. Okay. Well, I would.
Who's drafting the decision? Is it Matt?
Matt had done a draft.
Okay,
Yeah.
so if he's comfortable, I'm comfortable.
Yep. Yeah, I'm good with that. Jen, do you have the order of conditions as part of the?
I don't have those order of conditions, but I'm sure that Jeff can send it to me.
Okay. Yeah, that was my only.
I have order conditions that I did receive for the next hearing. Just what confused me because that's 73, but I know we'll get them and put them in the packet.
Okay.
Okay. Well, I'd make a motion to close the hearing.
Second.
It's been moved and seconded. All in favor? Woody Chidick, aye.
Darst, aye.
Charlie Higginson, aye.
Matt Watkins, aye.
Okay, 5-0. So the hearing is closed. Our last continued hearing of the evening. Oh, no, it's not a continued hearing. Begging your pardon. It's at 73 Whitehead Road. Cavanaro Consulting and Roger Wade, his client, would like to enlarge a detached garage. It's in the setback. It's also in the floodplain and add a living area above the garage. So they're seeking 8.7B relief as well as possibly 9/11 relief, which is the square footage on the ground. So, John, you're
Yes,
up?
good evening, Mr. Chairman, members of the board. For the record, my name is John Cavanaro from Cavanaro Consulting, and I'm here on behalf of Roger Wade. And with us as well, and Jen, if you could also promote Roger himself and Jim Kelleher, the architect for the project, I would appreciate that.
All set.
Great. And also what I'll do is share my screen if that's okay.
Sure.
You should be all set.
Great. So I'll take a walk through the site plan and go over the 2 items of relief. As you mentioned, we're here under Section 8.7 for dimensional relief as well as 9/11 for floodplain. So Roger's lot, located at 73 Whitehead Road, fronts on Whale Meadow on the Cohasset Harbor. It consists of his primary dwelling at 73, which is closest to the water. There's a detached guest house garage that's located closer to the street, a couple of sheds, and then the building that we're planning to remodel, which is also an existing garage that serves as an exercise area. So this building is the building that we're in front of the board this evening, in which we also presented this to the Conservation Commission at their last hearing, because as you mentioned, we fall within the floodplain, of course, and we also are within the 50-foot buffer and the 100-foot buffer zone to an adjacent coastal dune, which is seaward of a tennis court located on the adjacent lot. So the plan here is to, this is the existing building here, to zoom in a little bit. We have, the existing building itself is located about 3.5 feet, a little under 3.5 feet off the sideline. It is existing 15 feet in height, so by right it's allowed to be within a 6-foot setback, but it's a pre-existing non-conforming structure. It's been in existence well over 10 years, so it meets the definition of a pre-existing non-conforming structure. The existing structure itself is non-flood compliant. There are no flood openings, and it's located below the base flood elevation, which is elevation 10, and a VD88. The existing slab is around 9.2. The adjacent grade is just below elevation 9. So the proposal is to take down the existing structure and reconstruct it on its exact footprint with an extension of about 8 feet in the, I guess that's in the westerly direction. I'll have to zoom back a little bit here to get my north arrow. Yeah, it's in the westerly direction. And the building itself will maintain its 15-foot height to the midpoint of its highest roof, but it will also become flood compliant because we will add flood vents around 3 sides of the building to meet the building code requirements for flood compliance. We have been in front of the Conservation Commission. We did file for an order of conditions and a stormwater permit, both which were granted, and we did forward those to the board. We just received those recently. We sent those off to the board today, I believe. So you have those copies as well. With that, I think I'll open it up for Jim if you have any questions with respect to the architecture. I do have the architectural plans. Jim, if you'd like me to bring those up, or if you have those at your disposal as well. I'm not sure if Jim is muted or if he is with us.
He's with us, but he's muted.
I believe you're muted, Jim. There we are.
There we are. Jim Kelleher from Axiom Architects in Hanover. I'm not sure what to say. This is a pretty simple project. The existing building was 20 by 22 feet, and we're simply adding 8 feet away from the side lot line. And then we're raising it slightly, the roof pitch, so that we can fit a small guest room and a small bathroom above it. Because Roger's house has no second floor. He has no second, third bedrooms. He has visitors, so it's a guest room. So, and the garage will remain as a garage. So a garage can be allowed to flood, and we've just improved the flood situation because we got the flood vents. I think John gave you a pretty good sense of what we're doing. I show on the plan drawing. John, do you have that to put up?
Yes, I do.
I'm not that technically set up here.
No problem. Here's the proposed structure. Which do you want me to go to elevation
Start with
or
the plan.
view?
Why don't we start with the plan? So
Okay.
you just went by it. Oh, yeah, whichever. So you can see I've got a shaded corner there. That is, I believe it's like 2'6" by like 14 feet. And that's the only section that's non-conforming because of setback, the existing, pre-existing setback. And I have an area there in the setback of 23 square feet. So it's pretty insignificant. And the closest element on the adjoining property is a tennis court. There's no buildings really when you're at this building site. You don't see any buildings on that side of the neighbors. When I put the second floor on, I didn't put it on. I just steepened the roof and was careful to keep the midpoint below the 15 feet by about a half a foot. I'm about 14.7 to the midpoint. The peak itself used to be 14 feet, and I'm going to be up at 20'7" to the peak. So it's really not too much of an extension. And I did some cubic footage because I know in the past you've always wanted to know how many cubic feet were non-conforming. I have a little spreadsheet that didn't get submitted that shows the cubic footage of the existing non-conformance, which is about 260 cubic feet. As we add the roof, we get a much funnier looking little slice of cake that's non-conforming, and it extends the non-conforming volume by 102 cubic feet. So it's really small numbers. And I'm not sure what other questions you might have. As far as I can tell, it's completely within the height limits of an accessory building. And it is accessory because it's not a residence itself. So that stays within 6 feet. I believe I could build this new if I pushed it back 2.5 feet on that corner, under the bylaw as it's written.
Could you just explain that point again? I'm not disagreeing, I just didn't understand.
So by your zoning, by the zoning code, I can have an accessory building on a property that, if it stays under 15 feet in height and at least 6 feet from the property line.
Mm-hmm.
So what I have here is an existing garage, which is under 15 feet in height, but it's, what is it, John? 3'6" at one point from the side lot line, I think.
3.3 feet.
Yeah, 3.3 feet. So I'm asking for a continuance of that non-conformance. I'm not moving the building. I'm not expanding the building on that side. I'm going exactly using that exact slab for this building.
What's the existing garage setback from the road? How much? Does it meet the 100-foot?
Yes, it's 139 feet measured to the midpoint.
All right, I didn't see the number.
We measure to the midpoint on roads that are less than 40 feet for setback.
Okay, so.
But even so, it's a.
Jim's point is correct. If it would comply if you moved it back a couple of feet, you wouldn't need relief.
So what actually happens is when I peak the roof a little bit higher, I get a little more volume and I get a little bit more visual height from the side. If I was playing tennis next door, I'd notice the peak went up a few feet.
Yeah, by my calculation, it was an increase of 40%. I mean, you know, plus or minus, but about 40%, which is not egregious. I mean, you know, we often see 100%, which gives us pause. I don't find this personally very offensive or precedent setting.
I can't see that it has any negative impact on the neighborhood at all.
I'm just kind of curious about the need for all these bedrooms. I mean, they don't qualify as accessory dwelling units because they have to be attached to the primary dwelling, and they can't be rented, and they can't be occupied on a year-round basis. What's the does Mr. Wade understand those restrictions? It's his property. He can do, you know, within the bounds of the zoning bylaws, but you can't rent it. You can't occupy it full time.
Yeah, I won't speak for Roger if he wants to chime in here, but I suspect it's for his family and their extended family when they're visiting from out of town, and any other guests that he might have. But he's fully aware of the fact that these can't be converted into
He has
full-time dwellings.
real estate for enumeration.
I'm sure not.
He has grown children that come back, and of course, they want to come back for more than a day in the summer.
Sure.
This works perfectly because they're really, his existing dwelling is really quite minimal. The one that, and he can't improve it without having to conform completely to flood zone, which would be rebuilding the house.
John, am I muted?
No, you're not. We
Okay.
can hear you, Roger.
Yeah, no, it's just kids and grandkids and a spot for Woody to hang his head once in a while. Only when I run aground, Roger. You can rescue me.
Yeah.
Yeah, no, I mean, as long as you understand what the
Sure, of course.
restrictions are, that's your,
Yeah.
you know, I just wouldn't want to not mention it, but it's not at this point a concern of ours. Does the board have any other questions in this one? I'd like to open it up to anybody. Jen, you might let us know if there's anybody in the waiting line. Maybe
There's no one, yeah, there are
Does
no.
Don Hallen have any questions?
I have
or-
one quick, is
Oh,
there
sorry,
any
Charlie.
limit? Is there any limit to the number of accessory buildings you can have in a lot?
Well, it is interesting. There isn't. There may that as we write this, no. I mean, as we at this hearing, no.
Charlie, there
But
won't
as
be
they
any
say,
more.
it's not an accessory dwelling unit, though, Charlie. I mean, but you could put up another garden shed or whatever it may be. You know,
Yeah.
He's already got a pool house. He probably doesn't need two of those. But
The limit is actually lot coverage, and he's getting pretty close.
Yeah, I'm done.
you say with a smile, but with a chuckle. But we'll see. Anyway.
I just had one question.
Yeah, John.
Just, you might want to just check it for the, within 5 feet of the lot line, if it needs, fire resistant protection on that 5 feet. It just, you could take a.
You mean a building code issue?
Yes, so just, make aware of it. There's nothing else near that, so I don't think it's a big problem, but.
There's no other structure. within
Right, so
20 feet.
other than that, it should be all set.
Yes, but the board has taken the point of view that if you've got a vacant lot or at least, you know, land on somebody else's property, that doesn't preclude that somebody else from in the future building closer, you know, to the lot line legally. I mean, I'm not talking about creating a nonconformity, but coming within 20 feet, if you will. And I don't know if that would trigger if there was a building there, a dwelling within 20 feet of, or not within, at the 20-foot setback line, would that trigger John's concern about a fire retardant or fire?
It's just within 5 feet.
Okay, so, I mean, well, they can't. I don't think we'd allow a 5-foot, somebody to intrude 5 feet into the setback where 6 feet is the requirement.
Then we should be all set.
Yeah.
I think there's a stumble down stone wall along that between the two properties, isn't there?
There is. Charlie, so yeah, okay. I'm just sort of hypothetically dealing with something that could go there, but first of all, it'd have to be 6 feet. Would never, and I'm sure John wouldn't approve it either from a building permit standpoint. We wouldn't approve the creation of a nonconformity.
Right.
So anybody else wish to speak? Lee, are you waving your hand or just? I guess not. Do we need any other information, board? Oh, and Jen, there's nobody in the wings waiting to speak?
No one in the wings.
John, you've only been up about, John Cavanaro's only been up about 3 or 4 times tonight. Do you want to?
I'd just like to wish you all a very happy new year.
Ah, nicely done. Okay, thanks. Okay, well, I'd make a motion to close the hearing.
We actually would continue it.
I'll continue the hearing, sorry.
Yes, sorry.
Until February 2nd, we'll have a draft.
I second that.
Okay,
Continue.
moved and seconded, all in favor, Woody Chitik, aye.
Lee Darcey.
And I-
Matt
David
Watkins.
Morris, aye.
Okay, unanimous. All right.
Thank you very much.
And I think that, I'm looking for my agenda, I think that concludes, well, other than deliberations, and we have a couple of
That's correct.
deliberations to entertain tonight. And so, okay, we're now in a deliberation mode. There are no other topics, I think, reasonably expected.
That is correct.
Okay, so we closed the hearing on 31 River Road, correct?
Yes.
Yes.
And we have Matt Watkins' draft. Matt, you want to take us very briefly through the, where you came out and why?
I think it's my draft.
It's David.
Oh, David, I'm sorry.
Sorry.
Why do I?
So Dave, you did both River and Beach? I had thought Peter did River.
No, I don't.
Well, forgive me. It's okay. I'm looking at 31 River Road, a decision ZBA by MWW.
Maybe
That's what threw me off.
Huh?
Matt, you didn't write this.
No.
Oh, okay. So it's all right. So Jen, let's make a note that this was done by Dave McMorris, not Matt Watkins.
I will do that.
Not a biggie. Okay. So Dave, you want to take us through?
Templates.
I figured, Matt, you were on a roll. You just
I
a decision.
I just
fanatic
copied and
here.
pasted something Matt did. It's
all his fault. Matt did it.
When I was in law school, I had a professor that said the best lawyers are the best plagiarizers. There's no point in repeating work that someone else has already done. Okay, 31 River Road, the draft that you have, I drafted before this last change when they decided to, well, the first draft I did had the pergola. This draft that you have is after they decided not to do the pergola, but before we asked them to submit a revised application looking for relief under 900. So I had no problem with the project itself. I don't think that there's any detrimental impact on the neighborhood whatsoever. It's far away from any of the abutting properties. And the only abutting property that would have any potential impact on submitted a letter in support of the project. I will revise this to
The December 1st hearing. We'll have to modify that.
yes. I'll change the stuff on the December 1st hearing because it was continued and there was more material submitted after that. But I will address the floodplain issue as we don't find any detrimental impact on the floodplain, no wave action, et cetera. So I'll take care of that issue in my revised decision. But my recommendation is that we grant the special permit.
Yeah, I think it's a good solution. But
Yeah, my only question, I guess, as a group would be, I agree. I went out there a couple of times. I don't see that it's detrimental to the neighborhood. I know we talked about like the concern that we had with that the extension would, increase the existing nonconformity by, it says here, creating what is essentially a structure of greater size than the existing building itself. In other words, they have the existing nonconformity with the workshop. They're building something that's even bigger as an extension to it. We can look at that and say, it does, and I went out there, it doesn't have impact to the direct neighbor. The only question I would pose is, moving forward, if we have a situation like this, does this set precedence for us, or are we able to, and just use like, somewhere where it's tight, like a Pleasant Street, for example, are we able to take, a letter from a resident who, is not opposed to the project, and still look at I know we look at neighborhood as a whole, not just the one person next to it, which I think is an important point as well. But I'm just kind of putting it out there. it's one of those things where it's not egregious, I don't think, or it's not really detrimental to the property next door to it, but it's a pretty large extension to.
Let me put words in your mouth. If it were in your favorite street, Summer Street, and somebody was doubling the size of the garage in a setback, and you would be very concerned. Is that correct?
Right.
I would be.
So would I.
And I guess and if that applicant said to us, well, you just approved something similar, then we just have to say, well, it's a totally different footprint neighborhood.
Right. I think we would say that it's not similar in any way.
Yeah.
Mm-hmm.
Actually, my concern with this project was with the pergola. I really was concerned about having essentially a separate building in the setback that, rather than require a variance, only needed a special permit because it was connected with a pergola. Because I think it creates
well, to use your words, an artifice.
Yeah, it's an avenue for someone to circumvent the requirements of a variance. So while in this particular instance, I could see the sense of it because it did get them out of the flood zone. I much prefer the redesign because it eliminates that issue for us.
Charlie, how do you feel? Lee? I mean, where do you guys come out?
I agree with David.
I agree with David. And in your opinion, you might stress a little bit more that there's nothing else near it.
Okay, I can punch that up a bit.
Yeah, I think you've got, or somebody, I guess Roger Hoyt submitted the aerial photograph and so on and so forth. I mean, there's plenty of evidence that it's not just, hearsay. I mean, this thing is really set back. Now, 50 years from now, I have no earthly idea, but a lot of this couldn't be developed anyway because of the floodplain and wetlands. Yeah, I like it with those modifications. I'd frankly move to approve the requested relief. I don't see any reason to hold off until, well, we can't really, but ask for an extension of time. I mean, I think this is basically done. Do I have a motion to accept the decision as to be amended? But same conclusion.
I make a motion to accept the decision as amended.
Okay, it's been moved. Buddy second?
Seconded.
Charlie seconded. Okay, all in favor? Woody Chidick, aye.
Lee Darcey.
Colonel Higginson.
Dave McMorris, aye.
Okay, moved and seconded and approved. Okay, that's done. The second hearing has been postponed, Rustway, so that's nothing there. Elm Street, or the CHI, we've continued.
You need to assign a
I'd be
drafter.
happy to do that when the time's right. I mean, I think most of my concerns went away, but I do want to hear from Karis.
No, that's fine, but I would have, you agree to assign it tonight, and then we'll make sure you and Karis connect.
Okay,
And then you can
I mean,
report at the
if
next
somebody
meeting.
else wants to take this, I'm not trying to, but I think I'm due, is what I'm saying. I've avoided the last couple of months' decisions, so I'm happy to do this, but how can we communicate? We can't communicate. Karis can communicate directly to us. If I have a conversation with Karis about where our jurisdiction, if you will, stops regarding those parking spaces, I don't find any issues with the parking space at 87.
I would recommend that you allow me to reach out to her, and I know Cindy's going to do that tomorrow.
Okay.
And then we can have her submit a memo and that I can distribute to the board.
Okay, good, because I think everybody deserves to, a bite at this one and see if we agree. I'm not sure, listening to Adam, that.
But I would just wait to hear, because I know, as Adam said, and they've had a lot of conversations, and And we don't want to get into deliberation mode, but I think that's a good plan, and I will get that information for you.
Okay. The next is 89 Beach Street. I was recused, so I don't know, Charlie, where did you end up? Did you close that or not close that hearing?
We closed.
That was closed, and David wrote it.
Okay.
Still attributed to Matt.
Yeah.
See, it's
Boy.
you. It's not
Your
me.
Dave is just scribbing the heck out of these.
It could have been the quickest dealing with a doc portion of the decision that I've ever read too. Not that I would add anything, but I applaud you for your dealing of the doc in such a quick fashion.
Yeah, well, there wasn't much to talk about. Again, I got to revise this one because we had an extra meeting on it because they submitted another plan after the Concom, but it didn't change anything in my review of it. They didn't change anything regarding the dock that was part of our jurisdiction, and they didn't change anything with the garage that's part of our jurisdiction. So there's no substance in here that needs to change. I also have to change the Cohasset Mariner to the Patriot Ledger because Jen decided to throw me a curveball on that.
That's because nobody reads the Mariner.
It's their deadlines. They're brutal.
Well, man, this is not my hearing, so.
Okay.
Yeah, I didn't have any. I reviewed your decision, David. I thought it was good. I don't have any thing that I caught in it or any kind of edits or suggestions. I was in agreement with it.
I agree also.
Yeah, I agree with it.
Okay.
You need a vote.
Yeah, I would make a motion that we accept the decision as written by David, because it sounds like what was presented tonight, David, right? You said we don't have anything to add to it, so we'll just accept the decision as authored by
I
David.
got a little bit of editing to do to it, but
Okay. So yeah, I'll make a motion that we accept the edited version of David.
Lee Darcy, I second the motion to accept David's decision with edits.
All in favor? Aye.
Dave McMorris, aye.
Lee Darcy.
Yeah, Watkins, aye.
Okay, the next one is 72 North Main. Matt, you had drafted. This is a real draft of yours?
This is.
You actually drafted a decision. Okay.
Yep.
Does it say David on the bottom?
Yeah, well.
I actually didn't put the MWW on there, so we could. But yeah, I think this one was fairly straightforward too, as far as the dock was concerned. The initial proposal had about a 3-foot long portion, that was within our jurisdiction. When they went to Concom, it was modified, but only to be 6 feet within our portion. So there were no pilings that are located above mean high water. So our jurisdiction on this one was pretty limited. So I just had updated the draft with, between the first meeting and the second with the changes that were fairly minimal, and wrote a decision to approve the permit for the dock application.
Yeah, I thought it was fine. Did everybody have a chance to read it? I mean, there've been so many things. I've gotten a little confused as things go on, but anyway, I thought it was a good decision.
I read it this afternoon. I thought it was a good decision.
same here.
Do I hear a motion to approve Matt's decision?
So moved. Dave McMorris.
Lee Darcy seconded.
Okay, all in favor? Woody Chidick, aye.
Lee Darcy.
Jason, aye.
Dave McMorris, aye.
Matt Watkins, aye.
Okay, so that's approved. And the last hearing was the 73 Whitehead Road.
So you just need to assign
I
someone.
need somebody assigned. Whose turn is it?
My turn.
Okay. Did we continue that until,
Yes.
So
okay, so if you come next month with the draft, that's
Yes.
what we need there. Okay, yeah, that seemed to me pretty cut and dried as well.
Yeah. And John Cavanaro always does a great application. So
Yeah. And they really are, well, even the Kelleher, I mean, they're getting used to things like cubic feet and, you know, the volumetrics and massing issues that concern us. I've got to say that the implementation of the master plan has this zoning bylaw subgroup, and massing is a topic. We haven't advanced that very far. I think the zoning board is farther than anybody else in town regarding those issues, but there are a few towns, not many, that deal with, you know, the volume within a setback as opposed to the footprint. So we'll see where we come out, but that's an issue. But at any rate, I was pleased that Kelleher and as well as John have climbed aboard on that one.
yeah.
if we wanted to just go over, so the next two meetings,
Okay.
or February 2nd and March 2nd.
I've got such a busy social schedule with COVID-19 that it's,
We're all locked down.
God, just,
We do a meeting on Groundhog Day. Do we have to keep doing it over and over?
Over
again?
and over.
I have a feeling that everything is, this day is like a week ago or next week.
It's been 10 months of that. We might as well.
Yeah, those dates are fine with me.
All right, great.
Yeah.
And then I will have draft minutes. I've been starting them, but I didn't have a chance to edit them. I was working on other things. So I will get them to you.
Okay, hey, Jen and board, what I'd like to do is, as we start to make progress, Katie Dugan, who's I'm really getting to know her. She's really a terrific person who's heading up this implementation team or teams. I'd like to share with the board in some way that doesn't violate the open meeting law, you know, where we're going on some of this. The bylaws, I've been assigned, for instance, residential housing, residential bylaws, which are a dog's breakfast. I mean, they're everywhere. I mean, they've got definitions without any application and, you know, kind of restrictions without any definition. And it's really a mess. I think we'll straighten that out. But there are other issues as well that I think I'd like to very much have the zoning board jump in on a lot of these issues because they particularly affect us.
We've had a kind of a, like tonight, we had a fairly late night. Maybe we just put it on the agenda for one of the months where it's fairly light and talk about them.
Yeah, and I think it would have been premature up to now, other than letting you know who's on the work team. But I think you'd probably rather see some proposals or drafts or something and then have at it. But I think that it's a nice group, but the people that are involved are, it's sort of zoning light. I mean, I think this board has much more knowledge of how to apply the bylaws and how to get around them if you wanted to. And so I'd like the opinion of the board. I'm just trying to tee up some of this.
Winning.
What?
It's Charlie. He's not muted.
What were you saying? Boring?
My wife walked by and she's been watching the news. The Democrats are slightly ahead in Georgia.
Oh, good. But slightly is
Yeah, slightly still not.
not home. But I'd rather that than the opposite. I want to say two other things. One, another topic that we're going to deal with or starting to deal with is the harbor itself, not the harbor overlay district that pertains simply to the Elm Street Realty project, but the entire harbor. There are 6 different zoning districts from the yacht club all the way around to Trendowitz, one of which is light. Part of the marina at Trendowitz runs is in the light industry district, and to no one's understanding at all. And it is really a mess. And I think we need to straighten out, have a harbor. Personally, I think we need to have a harbor zoning district that isn't an overlay, that isn't designed to help a commercial interest, but designed to really protect the interests of the citizens. But every 100 feet, the zoning district changes, more or less, around the harbor. And I think that's a opportunity for chaos. So that's one topic. Residential bylaws and getting rid of a lot of crap in these overlay districts, which nobody has read, nor should you. I was going through one, and I'll just end, but I mean, I think we're going to be making recommendations at some point to get rid of some of these overlay districts, because they add virtually nothing. And I'm trying to remember what it is. There's one, maybe it's a water resource district, one that requires us to go to the Bureau of Mines manual and apply certain measures for the color of smoke. It can't be more than like a 0.4 or something on a scale. Odor. I mean, that's far beyond the purview of this zoning board and our enabling, chapter 40A. I don't know how these got in the bylaw in the first place, but they shouldn't be.
That's in our
there
bylaw?
at all. What?
That's in our bylaw?
Yeah. Yeah, it's just astounding. I don't know if it's a hazardous waste or it's I don't know. I won't take your time up now, but it's in there, and it's kind of laughable. I mean, I wouldn't not have any idea how to apply it, except it refers to the Bureau of Mines operating manual, section 7. Apply that.
Oh, hold on, let me pull mine out.
Yeah, no, I mean, I couldn't find mine. I must have put it in the ROM file, but
Are you saying mines like
Bureau, MINES?
Yeah,
that's how you measure it. No, it's strange. There is some overlay district in here or something. That's really weird. And I don't want to take your time up. But the other thing I've asked Jen to do is to ask. I don't know, Jen. I sent you a memo, didn't I? One of my concerns is that we have a rather extensive Section 9, which is a wetlands and floodplain district. And tonight is a great example. We deal with docks and a couple of other things, is the parking lot going to flood or not? And about 80 or 90% of it, I don't recall ever really applying it.
And you wanted to know, you had questions regarding the zoning board and also Concom overlapping on the jurisdiction?
Yeah, ideally, I would like to see Section 9 as a zoning bylaw paired back to things that really fall into land use and management, and not some of these other issues. But it may be legally required that we deal with all these. I don't know.
And I do remember you sending it to me, but it was a couple weeks before the holidays, so I think I just have to dig it out, and then I think it's
I think was Matt or somebody or Dave was right that we need to reserve some time. We could at least talk about some of these issues. Do we want to ask town council or other people to go further and find out, is this really a legitimate zoning?
Right. And I would say, we're in the process of acquiring some counsel to help us with the zoning bylaw working group. We're just waiting for confirmation of who that will be. And so this could be something that could be brought up then to assign to them at that point when we have the okay for the cost.
Yeah, but I don't know whether it was Dave McMorris or somebody mentioned to me a while back that I feel a little bad when people want to put in a dock, and of course most of the time they are not really financially strapped, but nevertheless they have to hire a lawyer, they have to hire an engineer. Well, they'd have one anyway, but they really need Concom approval. The width, the height is all by state code, and our jurisdiction stops at mean high water. And they really have to troop before us and spend another $1,000 or $2,000.
And all the stuff above mean high water is going to be Concom jurisdiction anyway.
Yeah, so we, as you said tonight, we've got a little 3-foot or 6-foot kind of spot.
I wonder if it's a requirement of Chapter 91.
Could be.
That, I mean, that's what we'd had to figure out as to why they had to make the third stop or second stop.
But maybe one could make a special permit, an SPP authority, the Conservation Commission, if for some reason, I mean, I don't know.
Well, 2 of these docks went within Inner Little Harbor, which one of them didn't need Chapter 91. So I don't, so there's got to, it's pretty complicated. It sounds to me.
Yeah, it's just that, I mean, there's a lot of stuff in our bylaws that we really don't deal with, and I don't know. It's not that I don't want to do it, but it seems to me why. There's the whole issue of, should the Conservation Commission jump in simultaneously with us, before us? We've, by and large, left them to opine after we meet. I don't know what the...
I know there's some sort of orders for special permits that they have to at least, what's one or the other? They have to file with us to go before them, or they have to at least file with Concom to come before you. And that is, I think, in the statute.
Okay, and if that's so, I'm not,
but we should be able to define it and make a chart so we know where and why, and if it's, a pathway, a flow chart, if you say, for people to follow what they need, what relief they need.
Yeah, it is a little bit confusing. Charlie, you wanted to say something. Didn't you raise your finger?
In the master plan, we were considering the advisability of making the zoning allow for more affordable housing. Has that been discussed at all?
There is the only article that dealt with affordable housing really, well, there are a couple, is Article 16, which is elderly affordable housing, and that's been sunsetted or discontinued, we think.
No, we're just confirming it. I think it has to have final action, but it has been.
So,
completed.
No, I mean, it isn't being dealt with. And I'm proposing, although nobody's seen it yet, that there be an article written, a special article on low and moderate income housing. You have to sort of go through the whole bylaw. You find a little bit at the transit oriented district, and there got to be 4 units down at the harbor, but they have different requirements for parking and everything else. And there ought to be one bylaw, and if something is unique because it's on the harbor or wherever else, then you could have a dispensation or special terms. But there are different height requirements. The transit oriented district is capped at 25 feet. The harbor's capped at 35 feet. Personally, it should be the other way around, I think, but I mean, there isn't any rhyme or reason. It just happened to be whoever proposed those overlay districts, which nobody reads in the floor of town meeting. And, so we have these semi-conflicting bylaws. But I don't know. I mean, I may be. But Charlie, you're right. We do have a Article 17, which deals with local initiative housing and things. But again, I think it probably needs, they talk about the width of the streets for one-way traffic and different kind of setbacks. I mean, that's fine, but I mean, I think, I don't know. Anyway.
I have an off-topic question.
Go ahead. No, maybe nothing's off topic.
Did we get sued, on the Oak Street, and has the appeals?
No.
We're past the appeal period, right?
Oh, hell yes.
Mm-hmm.
It's a 30-day appeal period.
20.
That's right. Interesting.
Speaking of lawsuits, is there any update on the Sandy Beach or?
I did ask, and I've heard that are trying to work it out together, but that's all I was told because it was an executive, but that the 2 parties are trying to work together. And that's all I know at this point, but I will ask Chris again. I asked the office if they knew, where we were, because I used to get all the updates and we don't get the updates. Like, we used to get all these memos from Deutsche Williams and we don't so much.
Is there a legal reason why we're not? I mean, or is it just
I don't think
people
that
overwhelmed?
I don't think that other firms spend as much time sending the briefs out, or the ones that we work with. We haven't had a lot of lawsuits. So for all I know, I don't even know who's handling it, to be honest, because we have so many lawyers, but I'll find out. And I know that they told me that they were trying to work it out. The two parties were trying to work it out together.
I honestly can't figure out, I have nothing against Paul Dorenzis. I just don't understand his role. Is he the official town council, or is Karis North the official town council?
He is officially town council by appointment that's been rolled since the 90s. Karis and her firm and we also have another firm we have another firm that we use for working with our unions, etc. Then we have this for land use, because when his firm broke up, he lost all the land use attorneys. And we had all these filings that we needed help with. And then our labor attorney also left at that time.
Yes.
So he is, so I still work with Paul on certain things. But we've had so much going on that we've had to go out for special counsel 3 years ago.
Is it just a question of this being new and I'm trying to figure out who does what, or is it in need of some rationalization?
Meaning, I think that
here's, if you're dealing with land use, here's where you go.
Right. I think that's what we had to just finally establish a place to go. And we always have to ask permission. It goes through the town manager. The board a few years back let him get special town council as needed based on the fact it was about the time, I think, that town council divided, and now it's just Brooks and Dorenzis. So, I mean, I was working with Paul on something recently, and Peter Barry is still there. But I think I believe ultimately at some point the board will go out for RFP, but I don't know the status on that.
Yeah.
Or an RFQ. I don't know. You don't have to, but it's a good practice to do so.
Okay, well, if February sounds like an easy month and we're not carrying over much, I mean, there are going to be a couple of drafts, frankly, that result from all this, no doubt.
Yeah.
Maybe we ought to reserve some time to talk about at least some of the zoning areas or articles that are going to be, are being looked at carefully, but also start to engage you. And if there are other annoying parts of this bylaw that you'd like to fix, let me know. Now's the time. What we're trying to do is mass these together. For instance, dimensional. There's some enthusiasm for lowering heights of buildings in certain districts, but rather than do that as a one-off, I think we've got to, and then changing setbacks. But that may be, I don't think it can be done in isolation. I think we have to look at the land and area as a whole.
So yeah, as of now, I only know of one filing coming in. That could change, and but we should reserve time on the next agenda that you can do an update on the zoning bylaw working group.
Yeah, and we could do, if Karis agrees, I mean, we could do a little simple handout for you guys because I really could use. I think we all could, not me. We could all use input. And the planning board doesn't deal with most of these issues.
Good.
Okay.
All right.
I'll find out where that crazy Bureau of Mines thing is. I know exactly in my vision, it's the upper left-hand page, but I can't find it. Any rate, and I'll let you know, just for your amusement.
Is it in the same area as the location of the Silly Walks? Because it sounds like a Monty Python.
Well, it probably, yeah, I mean, when I look at our bylaws, I'm just sure that these overlay districts, which tend to go 8 or 9 pages, longer than our section 8, by the way, longer than section 7 together, and they're inconsequential, but somebody has proposed these and solved every conceivable problem with words. And most of them, you know, we just haven't acted on them. But boy, I read the water thing. What is that? Number 14, Water Resource District. It's quite something. It really is. And we have to be in compliance with this and that. I don't know.
Wasn't that spawned by the Cohasset Heights landfill?
Yeah, I think so. It first came in '86, it says. Then it was changed in 2001, and then 2003. But it's, you know, they're also very well intended, but I defy you, you know, really. I have never in my 30 years read word by word, line by line, page by page until this last month. And it's something. I don't know what would happen if somebody came before us with a very complicated water resource district thing, but we may not even be the special permit granting authority. That's you know, who knows? Anyway, enough of that. We'll deal with more of an overview in February.
That sounds good.
But harbor, dimensions, the types of housing, our 3 work areas, certainly. And to try to get some clarity on. Okay, I mean, I'm monologuing here. Only I'm not as funny as Jimmy Kimmel.
You're riffing.
Who says?
Oh, well, Jimmy Kimmel would. I was listening to, I never listen to these guys. Not that I don't like them, but I just don't have the time. But I was looking at some little blurb in the news today, and Jimmy Kimmel was saying that his 6-year-old daughter, I guess it must have been last night or whenever, or end of last week, you know, was bemoaning COVID and, you know, it's so boring and I hate being stuck in the house. And boy, when COVID-19 is over, I'm going to have a party. And Jimmy said, man, he said, I encourage you to do so. We'll attend. As a matter of fact, you can drive us home. If you think about it, with the little 6-year-old driving you home. And I thought, funny, yeah, but.
That's true.
Really not.
Yeah.
Should we close?
Okay, so why don't we close the hearing?
All right.
Have a motion?
I move we close this hearing.
Lee Darst, I second we close this hearing.
Okay, moved and seconded. Woody Chitik, aye.
Lee Darst, I keep raising my hand.
No, but you're a great seconder, Lee. I mean, this seems to be, you know, I'm afraid to jump in the middle of this.
Matt Watkins, aye.
Okay, we have unanimity of the attendees.
My
Hey,
cats
Jen,
are
when you
fighting.
talk to Karis, and you and I can talk offline, but let's find out what I can or should share with this board as opposed to not share. I don't know if there's anything that shouldn't be shared, but
What do you mean for the zoning bylaw working group?
yeah, just to
Oh,
keep
No,
them.
I mean, it's those meetings are public.
Yeah,
People,
but
you know,
nobody
people
wants
could,
to sit through. Yeah,
they're during the day, so, but
yeah.
certainly any board member, we would just, if we ended up getting a quorum of the zoning board, I would just post it.
Well, I think in order to communicate with members of the working group, at least my work, you know, there has to be some summary material. So maybe I could share that.
No, absolutely. I think you can.
I'll run it by Katie. But
Plus,
this
there's
is not
also
secret.
minutes. There's also minutes that she writes that kind
Yeah,
of
she
go
writes
over.
good minutes. Yeah.
Yeah, and also the meetings are put on YouTube because
How about at least circulating to the zoning board, sending her minutes to the zoning board?
I could do that. They're
You can
also
get a little
available at our lovely
flavor.
website.
I
Yes.
know, but Well, maybe
I
they're
know.
more
Savvy than you
facile
think?
than I am.
Okay.
I'm
Yes, I can do that.
I'm stuck in the dark ages.
It's
Okay.
fine. I'll make a note,
All right,
email.
well, I'm not trying to just make you do more work.
It's
I-
fine.
By
It's
the
fine.
way, the topic came up at the planning board on the Avalon project, which has been sold. And Jen was good enough to refresh my memory. It's in perpetuity. Those, the affordable units are in perpetuity regardless of owner.
Yeah.
I think the only out is if the place goes bankrupt. You can't force somebody to, if they're going to change the use or something. But other than that,
Look,
Yeah,
it's
no.
a friend.
who is it alive?
Yes.
Looks like a big fuzzy toy. Oh,
They're
Right.
both,
Pomeranian?
he's a Persian, but they're fighting. I have two of them.
Oh,
They said they want Woody. They're just listening to Woody.
and they're going, okay, let's wind it up.
Wrap it up. That's what the,
All right, so we've voted,
And
we're
we're good.
closed.
all right.
good night, everybody, and happy new, happy.
Well,
New-
whatever.
All right.
Thanks.
Happy
Good to see
trails.
everybody. Happy trails. Woody, I'll be talking to you.
Okay, yeah,
Bye.
bye-bye.
Right.